Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Fourth Estate Public Benefit Corporation versus WallStreet.com. Certiorari to the United States Court of Appeals for the 11th Circuit. Argued January 8th, 2019. Decided March 4th, 2019. Petitioner, Fourth Estate Public Benefit Corporation, hereafter Fourth Estate, a news organization. Licensed works to respondent WallStreet.com, hereafter Wall Street, a news website. Fourth Estate sued Wall Street and its owner for copyright infringement of news articles that Wall Street failed to remove from its website after canceling the party's license agreement. Fourth Estate had filed applications to register the articles with the Copyright Office, but the Register of Copyrights had not acted on those applications. Title 17 U.S.C. Section 411A states that no civil action for infringement of the copyright in any United States work shall be instituted until registration of the copyright claim has been made in accordance with this title. The District Court dismissed the complaint, and 11th Circuit affirmed, holding that registration has not been made under Section 411A until the Copyright Office registers the copyright. The Supreme Court held, registration occurs and a copyright claimant may commence an infringement suit when the Copyright Office registers a copyright. Upon registration of the copyright, however, a copyright owner can recover for infringement that occurred both before and after the registration. Under the Copyright Act of 1976, as amended, a copyright author gains exclusive rights in her work immediately upon the work's creation, 17 U.S.C. Section 106. A copyright owner may institute a civil action for infringement of those exclusive rights, Section 501B, but generally only after complying with Section 411A's requirement that registration has been made. Registration is thus akin to an administrative exhaustion requirement that the owner must satisfy before suing to enforce ownership rights. In limited circumstances, copyright owners may file an infringement suit before undertaking registration. For example, a copyright owner who is preparing to distribute a work of a type vulnerable to pre-distribution infringement, example, movie, musical, composition, may apply to the Copyright Office for pre-registration. Section 408F2. A copyright owner may also sue for infringement of a live broadcast before registration has been made. Section 411C. Outside of statutory exceptions, not applicable here, however, Section 411A bars a copyright owner from suing for infringement until registration has been made. Fourth Estate advances the application approach to this provision, arguing that the registration occurs when a copyright owner submits a proper application for registration. Wall Street advocates the registration approach, urging that registration occurs only when the Copyright Office grants registration of a copyright. The registration approach reflects the only satisfactory reading of Section 411A's text. Read together, Section 411A's first two sentences focus on action by the Copyright Office, namely, its registration or refusal to register a copyright claim. If application alone suffice to make registration, Section 411A's second sentence, which permits a copyright claimant to file suit when the registrar has refused her application, would be superfluous. Similarly, Section 411A's third sentence, which allows the registrar to become a party to the action with respect to the issue of registrability of the copyright claim, would be negated if an infringement suit could be filed and resolved before the registrar acted on the application. The registration approach reading of Section 411A is supported by other provisions of the Copyright Act. In particular, Section 410 confirms that application is discrete from and precedes registration, while Section 408F's pre-registration option would have little utility if a completed application sufficed to make registration. Fourth Estate primarily contends that the Copyright Act uses the phrases "make registration" and "registration has been made" to describe submissions by the copyright owner. Fourth Estate therefore insists that Section 411A's requirement that registration has been made in accordance with this title most likely refers to copyright owners' compliance with the statutory requirements for registration applications. Fourth Estate points to other Copyright Act provisions that appear to use the phrase "make registration" or one of its variants to describe what a copyright claimant does. Fourth Estate acknowledges, however, that determining how the Copyright Act uses the word registration in a particular provision requires examining the specific context in which the term is used. The specific context of Section 411A permits only one sensible reading. The phrase "registration has been made" refers to the Copyright Office's act granting registration, not to the copyright claimant's request for registration. Fourth Estate's contrary reading stems in part from its misapprehension of the significance of certain 1976 revisions to the Copyright Act. But, in enacting Section 411A, Congress both reaffirmed the general rule that registration must precede an infringement suit and added an exception in the provision's second sentence to cover instances in which registration is refused. That exception would have no work to do if Congress intended the 1976 revisions to clarify that copyright claimant may sue immediately upon applying for registration. Noteworthy, too, in years following the 1976 revisions, Congress resisted efforts to eliminate Section 411A, which contains the registration requirement. Fourth Estate also argues that because registration is not a condition of copyright protection, Section 408A, Section 411A, should not bar a copyright claimant from enforcing that protection in court once she has applied for registration. But the Copyright Act safeguards copyright owners by vesting them with the exclusive rights upon creation of their works and prohibiting an infringement from that point forward. To recover for such infringement, copyright owners must simply apply for registration and await the registrar's decision. Further, Congress has authorized pre-registration infringement suits with respect to works vulnerable to pre-distribution infringement, and Fourth Estate's fear that copyright owner might lose the ability to enforce her rights entirely is overstated. True, registration processing times have increased from 1 to 2 weeks in 1956 to many months today. Delays, in large part, are the result of the Copyright Office staffing and budgetary shortages that Congress can alleviate, but courts cannot cure. Unfortunate as the current administrative lag may be, that factor does not allow this court to revise Section 411A's congressionally composed text. The decision below is affirmed. Justice Ginsburg delivered the opinion for a unanimous court. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80. Thank you.